Hi everyone, a very good evening to all of you to the live virtual classes of Board of Studies ICAI. And we are dealing with CA intermediate course in paper 2, corporate and other laws. We are discussing the topic General Clauses Act 1897. We already had one session yesterday and we have covered some portion of it, and we will continue with the remaining sections today, and we intend to complete General Clauses Act today. Let us have a quick recap as to what we did yesterday, so as to make it a revision as well. So yesterday I told you about the learning outcomes, and we broadly covered the four learning outcomes. That is, you are now in a position to explain the purpose of General Clauses Act, and you also acquired some basic understanding of the legislation, how it is arranged, why there was a necessity for this legislation, and some general definitions we looked at. We covered all the definitions broadly, but the major ones we looked at in detail. Like, for example, immovable property, we saw it in detail, and some of the definitions which are remaining we will cover today. And then we discussed about general rules of construction under Section 5 of the General Clauses Act. Today, we are going to look into the other dimensions of the law. And this is what till Section 7 we had covered the things in our previous lecture, and the remaining sections today we are going to cover. But before we move on, let us quickly practice a few questions which are there and which have been featuring in your examinations. So let us get some response from you on this. So one of the questions, and this is of probably a 2-marker, a 4-marker question, which says, how will you interpret the definitions in a statute if the following words are used in a statute? That is, means and includes. So this I gave you a detailed explanation on means and includes, as well as may and shall. So looking forward to your answer on this. Can you explain this? Yeah, go ahead. Means and includes. Can you tell which one is exhaustive and which is restrictive? You can use the chat box, or you can speak as well if you are permitted. Yeah. Are you able to hear me, all of you? Can you say yes once?
Yes, sir, you are audible.
Okay. Participants, would you like to respond to this question? This is means and includes. This we covered yesterday. I just wanted to have a quick recap. Okay, never mind. If we look at these means and includes, interpretation of the words means and includes with the definitions. So if you see the mean is restrictive definition, and when you go ahead, include is a extensive definition or exhaustive definition. So you can include. So this is how it is. So the word mean is to define such and such, that is prima facie restrictive. And exhaustive, we must restrict the meaning of the word to that given in a definition section if there is a word means. If you are using includes, then you can have more number of similar things into it. So that is the example we can give. One is definition of director. So director means director appointment by the board. Whereas full-time director definition, if you see under 294, it says full-time director includes a director in the full-time employment of the company. So this suggests an extensive definition. Other directors may be also included in the category of full-time director. Now let us look at the other question. And this question is, explain the following with reference to provisions of General Clauses Act. One is movable property and the other one is oath. So can you give an explanation? Movable property is an interesting one. So movable property is a property which is not immovable property. So what is a immovable property? That you have to tell. What is immovable property? And how do you distinguish between movable and immovable property? This is section, which section? Section 326. Very good, Sushmita. And it talks about immovable property. So immovable
ಅವ್ರಿಗೆ
property
ಯಾರು
is
ಆನ್ಸರ್ ಆಗಿ ಬಿಡು ಮಾತಾಡ್ರ ನಾ ಪೇಪರ್ ಕೇಕಿದ ಅಂತ ಡೌಟ್ಗೆ
generally land, and then we are having land and standing crops and things attached to the land. These are the things which are included in the definition of immovable property. And if you have a look at, this is what the immovable property description is. Then we have seen definition of oath as well, and oath will include affirmation and declaration in case the persons of law are allowed to affirm or declare instead of swearing in. So swearing in is different than oath. Swearing in is a situation where you swear in the name of the God, right? Now, let me take you to another question, and this is a question, just read it. ABC Real Estate Limited, a prominent real estate company, has recently acquired a piece of land in a suburban area. The land has a small lake that is expected to generate significant tourism revenue in the future. Additionally, the land has several old structures that are permanently fastened to the earth, such as a stone pavilion and a historical monument. ABC Real Estate Limited plans to develop the area by refurbishing the existing structures and enhancing the natural surroundings to attract tourists. Now consider the above scenario. Identify which of the following components are classified as immovable property under the General Clauses Act. What is your answer? Only the land and the stone pavilion? Only the land and the benefits arising from the lake? The land, benefits arising from the lake and the stone pavilion? Or the land, the benefits arising from the lake, the stone pavilion, and the historical monument? Which one? Good. So most of you have answered correctly. It is D because it talks about all the four. So the land, and these are the four elements which have been given in 3 subclause 26 as definition of immovable property. Now let us move further and talk about this another question which tells you that differentiate between mandatory provisions from a directory provisions. What factors decide whether a provision is directory or mandatory? What do you have to say? This is a question. This question has been asked in one of the examinations. Yeah. Go ahead. Mandatory provisions uses shall, directory provisions uses may. Sushmita, you are right, prima facie, but it is not always a case that shall means mandatory and may means directory, right? So this is a very important exceptions which you have to write and give a situation about it. Okay. So if we have to explain, we can always say, practically speaking, the distinction between the provisions which is mandatory and the one which is directory is that when it is mandatory, it must be strictly observed. When it is directory, it would be sufficient that it is substantially complied with. However, we have to look to the substance and not merely the form an enactment is mandatory from form might substantially be directory, and conversely, a statute in directory form may in substance be mandatory. Hence, it is the substance that counts, context that counts, okay, and must take precedence over mere form. If a provision gives a power coupled with a duty, it is mandatory. Whether it is or not so would depend on considerations such as the nature of the thing empowered to be done, the object for which it is done, and the person for whose benefit the power is to be exercised. So you have to see the context, you have to see the factual situation, and then say whether it is mandatory or directory. But a general idea is that wherever there is a shall, you generally read it as mandatory, and wherever there is may, you read it as directory. However, in a peculiar circumstances, shall may mean directory, and may mean mandatory. Depends on the cases and situation. We have discussed that in detail. And when tomorrow we discuss interpretation of a statutes, I will be explaining few more examples so that you have more clarity. Let us move further and talk about this example. This example says Income Tax Act 1961 provides that the gratuity paid by the government to its employee is fully exempt from tax. You are required to explain the scope of the term government and clarify whether the exemption from gratuity income will be available to the state government employees also. Give your answer in accordance with the provisions of the General Clauses Act. So you recollect the definition of the government, and we also looked at one of the examples on union territory. So this is that particular point. So can you explain this, whether here the state government will be included? Yes. Good. Vishakha, you are right. Now let me look at this particular answer. So according to section 2 subclause 23 of the General Clauses Act, the government shall include both central government and state government. Hence, wherever the word government is used, it will include central government and state government both. Thus, when the Income Tax Act provides that gratuity paid by the government to its employee is fully exempt from tax, the exemption from gratuity income will be available to the state government employees as well. Okay. Now we move on to our next section. So thank you for your inputs. And I think we are on right track. You have understood the concepts which we have discussed yesterday. Section 8 talks about construction of references to repealed enactment, right? So we were discussing about repeal of laws, right? Section 5 or construction of laws, and in that repeal of laws is a very important section. So section 8 says construction of references to repealed enactments. So it says where this act or any central act or regulation made after the commencement of this act repeals and reenacts with or without modification any provision of a former enactment, then references in any other enactment or in any instrument to the provision so repealed shall, unless a different intention appears, be construed as references to the provision so reenacted. Now you can see the language is a bit twisted, right? So it is making reference to the older law, the new law, then older law. So we can understand this in a simplified language. And if I have to give you a simplified language, and this example comes from your course material itself, it says in section 115 JB of the Income Tax Act 1961, for calculation of book profits, the Companies Act 1956 are required to be referred. Okay. Now, with the advent of Companies Act 2013, the corresponding change has not been made in section 115 JB of the Income Tax Act. And this situation we have seen before also. If you see section 6 of the Act, we have talked about one of the situation talks about this. But section 8 specifically is dealing with this point. On referring of section 8 of the General Clauses Act, book profits to be calculated under section 115 JB of the Income Tax Act will be as per the Companies Act 2013. So there will be an automatic reference. This is what it is trying to say. Subclause 2 of the law says, where before the 15th day of August 1947, any act of Parliament of the United Kingdom repealed and re-enacted with or without modification the former. So this subclause is not that greatly relevant for you because this was for the purpose of the British laws applicable to Indian scenarios. I think now we are more than 75 years of independence, so there, I don't think that any situation remains which may be applicable, but it features in the statute book, so let it be there. Now let us look at the provision with reference to repeal of laws. So you may have heard our government is in a mission to repeal all obsolete laws. So what happens is that law keeps enacting by the legislature. Many a times the purpose of the law is fulfilled. There is law, there is no need for that particular law to exist, but still it exists in the statute book. Now, when a law is there on a statute book or in a law book, it has got a legal validity and you have to refer to it. You have to always keep it in mind. And unnecessarily, it creates confusion. And hence, periodically, there is a requirement of repealing these laws. Like, for example, if you see this Repealing and Amending Act of 2023, it repealed a series of laws. Many laws which were of no use were repealed. So if you see, there were enactment in first schedule, third schedule. These were different lists which has been repealed by the central government, right? So if you look at section 8, it tells you that when a later statute incorporates by reference the provisions of an earlier statute, a repeal or amendment of the earlier statutes do not affect the later statute or provisions incorporated therein, right? And if I have to look at example, one of the example could be repeal and replacement of Mines Act 1952. So when Mines Act 1952 got repealed, the definition of coal mine, which was there in the Mines Act 1923, in the Coal Mines Provident Fund Act, was construed as referring to the definition of coal mine in the Mines Act 1952. So, though specifically coal mine was not defined in the Mines Act, but they took the definition from Mines Act 1923 to, make sense of this provision. So the state of Bihar versus S.K. Roy is an example of this section 8. I hope this makes sense to you. We have already seen section 6, which talks about repealing and amending act. So one of the examples could be that when Insolvency and Bankruptcy Code Amendment Act of 2018 and the Insolvency and Bankruptcy Code Second Amendment Act of 2018, they repealed by repealing and amending Act of 2023, it does not affect the changes brought up by these amending acts. So whenever new amending act comes up, whatever actions which has been taken previously under that law still exist. Okay. So this is about section repealing and amending act. Many a times there is a confusion between section 8 and section 7. So this is a comparative chart which gives you explanation between these two. So if you see section 8, it is principle involved here is that when a law is repealed, the repeal and replaced by a new law, references in other enactments to the old law are read as references to the corresponding provisions of the new law. Like, for example, say A contains section 10 and Act B repeals Act A and reenacts the same provision as section 25. Another statute refers to section 10 of Act A. Now, after repeal and reenactment by virtue of section 8, that reference is read as referring to section 25 of Act B so far as the provisions are corresponding. I hope this example gives you very clarity as far as section 8 scope is concerned. Now, section 7 talks about revival of repealed enactments. So, principle here is that if Act A is repealed by Act B and Act B is later repealed by Act C, Act A will not come automatically revive because Act Act C is repealed, that means which was repealing Act A. So automatically it will revive. That will not happen. Legislature must expressly state that the Act A is revived. So there is no automatic revival by virtue of Section 7. So if we have to give an example, Act A, that is 2010, regulates street vendors. Now Act B 2015 repeals Act A, and then Act C in 2025 repeals Act B. So you can see here Act B was basically repealing Act A. Now when Act B itself gets repealed, whether Act A will automatically come into force? No. Act A does not come back into force merely because Act B has been repealed. To revive Act A, Act C must expressly provide Act A shall stand revived. So I hope this gives you clarity why this provision is there. This provision is there because there should not be any confusion, right? Because there should be sufficient clarity in terms of the legislation and its enforceability. If it is not the situation, then it becomes a problematic situation later. Now let us look and move further. And if you see, the difference between them is that Section 7 prevents automatic revival of repealed enactments upon repeal of repealing act, whereas Section 8 ensures continuity of statutory references by treating references to a repealed and re-enacted enactment as references to the corresponding provisions of the new enactment. My advice to you people would be that legal language is bit twisted and a bit difficult to remember as it is. So remember them through examples. So probably these examples, if you remember in your own mind to get the explanation of the law, it will be easier for you to remember them. Now let me move further and talk about a situation, and let us see what is your response to this. So this is with reference to Section 218 subclause AA of the Income Tax Act. And this provides that a company is said to be a company in which the public are substantially interested. If it is a company which is registered under Section 25 of the Companies Act, after the advent of Companies Act, after the advent of Companies Act 2013, the corresponding change has not been made in Section 218 of the Income Tax Act. Explain with reference to the provisions of General Clauses Act, how will the provisions of Section 218 AA of the Income Tax Act will be considered after the enactment of Companies Act 2013. Can you now explain what will happen in this situation? Use this chat box to respond. Or you can open your mic also to speak if you want. Yeah, go ahead. Yes. Could you get it? Sushmita, your answer is the provision of Section 218A will be automatically given reference to wherever it is used. No. Provisions of IT Act will be considered as their unless specifically changed. No effect. Okay. But here, IT Act is the base legislation, which is the referenced act. Referenced act is Companies Act 1956. So you people have not got it properly. Yeah. So here, which is changing? Yeah, the Companies Act 1956 is there. Yeah. Right, Sridhar. So it is Companies Act automatically when it will be repealed, the provision, approximate provision from the Companies Act 2013, it will switch automatically. This is what is the provision. Okay. So you can see here, previously under the Companies Act, it was Section 25 of the Companies Act. Now under the Section 25 deals with basically charitable companies, right? So now under Section 8 of the Companies Act 2013, same provisions are dealt with. So Income Tax Act 1961 refers to Section 25 of the Companies Act. Now by virtue of Section 8 of the General Clauses Act, they will be referring to the new provisions. That is Section 8 of the Companies Act 2013 automatically, right? And there is also a reference of Gauri Shankar Gaur versus State of UP. This is the case. And it says that every act has its own distinction. If a later act merely makes a reference to the former act or existing law, it is only by reference, and all amendments repeal new law subsequently made will have effect unless its operation is saved by relevant provisions of that section of the act. Unless there is a specific provision of non-reference, the provisions will be referred to. I hope this is you got the clarity. Okay, so it is not the Income Tax Act, it is the Companies Act which is of relevance here in this case. Okay, now let us move further and talk about another important section which talks about commencement and termination of time. So this is section 9. And section 9 says that in any central act or regulation made after the commencement of this act, it shall be sufficient for the purpose of excluding the first in a series of days or any other period of time to use the word from, and for the purpose of including the last in a series of days or any other period of time to use the word to. Now, basically, this section applies to all central acts made after the 3rd January of 1868 and to all regulations made on or after the 14th day of January 1887. Now, you will see this objective of this particular law basically is to give clarity which day to include or exclude when you are calculating the days, right? So, in an example which is given in your literature is a company declares dividend for its shareholders in its annual general meeting held on 30th 9 2022. Now, under the provisions of the Companies Act 2013, company is required to pay declared dividend within 30 days from the date of the declaration. That is from 1/10/2022 to 30/10/2022. In this series of 30 days, 39/2022 will be excluded and the last, that is the 30th day, will be included. So this is the provision 9, section 9 talks about that. Now you may be thinking, that this is such a small matter. Why the law provides that? But surprisingly, even matter of hours, days, half days are important when limitation periods comes in. So I don't know whether you people are aware about the Limitation Act. So there is a Limitation Act, and the Limitation Act tells that when a suit is barred from litigation. So even one day counts there, right? So if it is barred, like say, for example, you have to file an appeal over an order within 45 days. So you, as per section 9, you have to look for which days. You have to see, you can include the last day, but exclude the prior day. So from day has to be excluded and to day has to be included. This is what section 9 tells you, and the relevance of this particular section in legal circles is that. Let us look at this example. And let me hear what is your answer. A Limited declares a dividend for its shareholders in its AGM held on 27th September 2024. Referring to the provisions of the General Clauses Act 1897 and Companies Act, advise the dates during which A Limited is required to pay the dividend. What do you say? What would be your answer if you have to deal with this? 28th September to 27th October. Okay, Vishaka, that is your answer. Any more answers? Anyone wants to differ? Okay, Isha says 28th October, within 28th October must be paying the dividend. Okay. What else? Which provision of the Companies Act deals with the dividend? Okay, good. So let us look at what is the solution. So as per section 9 of the General Clauses Act, for computation of the time, the section states that in any legislation or regulation, it shall be sufficient for the purpose of excluding the first in the series of days and or any other period of time to use word from, and for the purposes to including the last in a series of days or any other period of time to use the word to. Now, in the given instance, A Limited declares dividend for its shareholders in its annual general meeting on 27th. Under the provisions of Section 127 of the Companies Act, a company is required to pay declared dividends within 30 days. That is from 28th September to 27th October 2024. In this series of 30 days, 27th September will be excluded and last 30th day, that is 27th October, will be included. Accordingly, A Limited will be required to pay dividend within 28th to 27, both days inclusive. Good. So I think you have understood this provision. Now let us move further with another example. What would be the answer? This is kind of a similar question. For your information, these questions have been asked in different examinations. Okay, so that is picked from your question bank. So these are the questions comes similar kind of situations will be coming. Go ahead. August 9 to 7 September, both days inclusive. Okay, good. So Isha, I think you have to, your answer that is should pay dividend within 7 September 2023 may not be the correct answer. You have to, as per section 9, you have to talk about both the days inclusive, okay? Because 30 days when you are calculating, then you include the starting day and end day also, okay? It is very important. So you can see here, that is we are talking about. So it will be 9th August 2023 to 7th September 2023, both days inclusive. This is what would be your answer. Okay. Because 8th August was the day on which it was declared. So after that, you go ahead with the next day from, that means the next day, 9th August, wrong answer. Okay. Now let us move further and talk about in another important section. And this section deals with computation of time. So section 10 says that whereby any central act or regulation made after the commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed period, then if the court or office is closed on that day, or the last day of the prescribed period, the act of proceeding shall be considered as done or taken in due time if it is done or taken on the next day afterwards on which the court or office is open, provided that nothing in this section shall apply to any act or proceeding to which the Indian Limitation Act applies. Why it is saying that this situation will not apply in the Indian Limitation Act? Because Indian Limitation Act automatically provides for this situation. Okay. So this section applies also to all central acts and regulations. So what basically this section is saying This section is telling you that if there is a holiday which falls on the statutory period of appeal or certain requirement of a day, then you exclude that day and next working day will come into picture. Like say, for example, a Central Act requires an appeal to be filed within 30 days and the 30th day falls on a Sunday where court is closed. So as per the application of Section 10, the next working day, that is Monday, will be considered within time as per the law. So the appeal can be filed on day 31, that is Monday, will be valid. I hope this is clear to you people, all of you. Similarly, this happens many a times. Like for example, this time you would note that the Eid was on 27th and later on government declared it on 28th, right? So say for example, somebody kept in his mind that, okay, fine, last day of filing the appeal was 27th and 28th, 28th, and they thought that, okay, fine, after Eid we will file it. And later on, the government declared 28th as a holiday. So now on 28th, they cannot go to the court and, file the appeal. So now they can file on 29th. So this is what this section helps in understanding that. I hope this is clear to you people. Okay. So this helps. By the way, courts have been very, kind, and they have been to doing justice. They have been relaxing the provision of timelines many a times. Like for example, if you recollect the COVID days, COVID-19 period, the courts have relaxed all these particular timelines for enforcement of contract, and this for about a year, right? So these are exceptional circumstances. But in a general circumstance, as per Section 10, you exclude the holiday if it is falling on the limitation period. These are all by abundant caution, because many a times our country is so big. There are so many courts. One may go and some strict judge is there and they will say that, okay, the rule doesn't permit, I don't allow you. Hence, these provisions are very much made in the law to facilitate justice. I hope this is clear to you. Now, let us move further and talk about a situation. Can you read this and explain? Give the answer. So, Mr. Sohan has issued a promissory note of 1,000 to Mr. Mohan on 17th May, payable 3 months after that date. After that, a sudden holiday was declared on 20th August due to Muharram. This is the similar situation as I explained you just now, because Muharram holidays, Eid holidays are dependent on the moon, and it comes at a later point. So, as per the provisions of General Clause, what should be the date of presentment of promissory note? Whether it should be 19th or 21st, very good. So, this is what the law is. So you have to, when you answer, you have to answer completely mentioning these particular provisions and a bit of an explanatory note. Okay, now let us take you to another question. What would be the answer in this case? Okay, Vishaka, that is 31st. Right. So this is good. So you have understood this provision, section 10, very clear. Now let us move ahead and talk about a very important section, that is section 11. Section 11 talks about measurement of distances. So it says, in measurement of any distance for the purpose of any central act or regulation made after the commencement of this act, that distance shall, unless a different intention appears, be measured in a straight line on a horizontal plane. So whenever there is a requirement of distance, you will be measuring it on the basis of the straight line on a horizontal plane. Now, what is this? This is basically required in terms of measurement. So I hope you people have seen this particular instrument. Many a times in construction of roads, this particular instrument is taken into consideration and it measures the distance. Uh, as far as measurement of land is concerned or measurement of distance is concerned, in different places you have different terminologies like list of acre, hectare, bigha, gaj, kattha, guntha, biswa, decimal. These are different terms which are utilized. But if you have to measure it, you look at the aerial distance. Basically, this horizontal plane, when you talk about it, it is the aerial distance. You don't look at the round road and then calculate it. So always, wherever there is a question of measurement of distance, you look at the horizontal distance. As you can see here, in case of, particularly in case of mountains, I stayed in Uttarakhand for some period of time, and there I was wondering how they measure the land. So there, this is how the land would be measured. It will not be on the basis of slope distance, but it will be on the basis of the horizontal distance h. So what they will do is they will create a 90-degree angle from the ground, and then from the top they will measure the aerial distance. So h will be the distance which will be calculated as the distance between point A and point B, and not s. This is basically the slope distance. So now practical utility of this provision, you can see, like for example, there is a law which prohibits any tobacco or any activity from the premises of a university or a school. So 100 meters it is. So you have to calculate 100 meters. Where do you calculate from? The aerial distance from the last point of the university or a school. And you see. Similarly, you will see there is a regulation of the government which says 500 meters from the highways. There should not be any, liquor shop. So that is also one of the this. So how do you calculate that distance? By way of a aerial position. What do you say in this? I think this is self-explanatory. Can you explain this example? Give an answer to this. What would be the answer? So the Ministry of Transport is planning to construct a new highway that will connect city A to city B. According to the initial plan, the highway is expected to cover a distance of 150 kilometers. So how it will be measured? Okay, very good. So you all have answered. The distance would be measured in a straight line on a horizontal plane unless otherwise specified. So it will not be measured by way of existing roadways and curves or natural terrain obstacles, or may be measured as a combination of straight lines or natural curves. Okay. Now let us move ahead. This is another example. Can you read that? So this is the example which says basically Mr. Chhagan Lal is an importer of dealing with luxury perfumes. Recently, a new enactment was passed which imposes a duty of 15% on the value of luxury goods, including perfumes. Now, Mr. Chhagan Lal has approached you, explain to him the provisions in relation to duty to be taken pro rata in enactments of General Clauses Act. Also help him to calculate the amount of duty on a shipment of 100 bottles of perfumes, each valued at rupees $50. First of all, my question is which provision of General Clauses Act it talks about, and what would be the answer? Section 12, Vishaka, very good. And what would be the answer in this situation? Calculate and tell. Okay, $750. Yes, Sushmita, we have not done these provisions, but we are doing it now, right? So it is section 12, which says duty to be taken pro rata in enactments. So whereby any enactment now in force or hereafter to be in force, any duty of customs or excise or in the nature thereof is leviable on any given quantity by weight, measure, or value of any goods or merchandise, then a like duty is leviable according to the same rate on any greater or lesser quantity. So here in this case, what you have seen, there is 100 bottles and $50. So 15% you apply and it will be $750 of duty, which will be paid in this case. So the people who have answered, very good. You have understood it well. Let us solve this one. Under an enactment, an excise duty of 10 is levied on every 100 liters of a certain chemical produced in a factory. During inspection, it was found that factory A had produced 350 liters of that chemical, but had paid duty only for 300 liters, arguing that the Act only specifies duty per 100 liters and does not mention functional quantities. With reference to the General Clauses Act, determine whether the factory is liable to pay excise duty on the remaining 50 liters. Support your answer with reasoning. There's a 4-mark question. So you have to give the answer as well as at the same time you have to provide the provisions in detail. Looking forward to your response. Yeah. Okay, Vishaka, what is the answer? Calculate it in on a piece of paper, or if you are having on mobile on calculator, you can do that. Then give me the response. Pro rata you have to work out. So on 100, it is 10. So how you go ahead with that? Okay. Need to pay 5. Fine. So which provision of the law? Which provision of the General Clauses Act requires this? Section 12. Very good. Right. So this is what is the answer according to Section 12 of the General Clauses Act, whereby any enactment now in force hereinafter to any customer or excise or nature thereof is leviable on any given quantity by weight. That duty is leviable according to the same rate. So thus, when a statute fixes rate per unit, it applies proportionately to fractions of that unit. So the logic given by this gentleman here is not correct. And if in this case, factory A produced 350 liters, only 300, leaving 50 liters unpaid, applying section 12 of the General Causes Act, the expression 100 liters. Here, this is not 13, by the way, it is section 12. There is a mistake here. Typographical. So the expression 100 liters must be read in a manner that covers any multiple of fraction thereof. Thus, total duty to be paid would be rupees 35. Right? 350 by 10. Therefore, factory A is liable to pay excise duty on the remaining 50 liters of chemical, also which amounts to 5. Okay. Let us now look at another section, that is section 13, which talks about gender and number. So it says in all central acts and regulation, unless there is anything repugnant in the subject or context, words importing the masculine gender shall be taken to include females, and words in the singular shall include the plural and vice versa. So say, for example, if there is a he, then it will include she. If it is talking about one person, it will include many persons also. So it is not necessary that every time it should mention clearly, because it becomes cumbersome otherwise, because they cannot visualize whether there will be one person affected or many persons affected, whether it will affect only males or females or transgender. Now you will see under the General Clauses Act, there is no mention of, transgender. It is only talking about gender and gender of males and females. So this will get affected by the new change by way of Bharatiya Nyaya Samhita. So if you have a look at Bharatiya Nyaya Samhita, it defines gender and it says the pronoun he and its derivatives are used for any person, whether male, female, or transgender. So even it includes transgender. So transgender shall have the meaning as assigned to it under the Transgender Persons Protection of Rights Act. So as the picture shows you, you can see here, one, the words importing masculine gender will be including females and also the transgenders. And word in singular shall include plural and vice versa. So whenever there is a person, person may include persons as well. Okay. So this is the section 13. I think it is self-explanatory. To make it more clear in statutes, there is no chance of confusion. It is made like that. Okay. Now let us look at a problem. Read this problem and try to answer. You can see here, there is one lady called Mrs. Nilu Chandra, and she was director of Laddu Sweets Private Limited. And once while dealing with supplier of raw materials for company, she agreed to get some secret commission from supplier for making the deal. Afterwards, on finding the facts, the company has filed the suit against Mrs. Nilu Chandra. She contended that Section 166, which talks about related party transactions under the Companies Act, provides a director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, partners, or associates. And if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to gain of the company. Now here her argument is that Section 166 is applicable to only male directors, and she being the female will not be liable. So in light of the provisions of the General Clauses Act, decide whether she is bound by the provisions of Section 166 of the Companies Act or not. So see, this is a practical problem. What do you say? She will be bound by the provisions. Okay. By what provisions? By Section 13. Okay. So you see here, by virtue of Section 13, she will be bound by the provisions. Okay. I hope this is clear. This provision is clear. Okay. Any question till this point? To any one of you? Any question? No question? Okay. If there are no questions, let us proceed further. Now we are talking about the powers and functionaries. Okay. So if you will see section 14 to 19 talks about powers and functionaries. So section 14 talks about powers conferred to be exercisable from time to time. Section 15 talks about power to appoint to include power to appoint ex officio. Section 16 talks about power to appoint to include power to suspend or dismiss. Section 17 talks about substitution of functionaries. Section 18 talks about successors. And Section 19 talks about official chiefs and subordinates. So you will notice that these powers and functionaries provisions are there made in General Clauses Act to assist administration effectively, because running the administration is not that easy. there may be situations where the official is not present in the seat, they have to exercise powers, and these powers may be challengeable, that it is not legitimately exercised. So in all those situations, law must provide some mechanism to deal with it. So if you see section 14 basically talks about powers conferred to be exercisable from time to time. So it says basically that if you have been given a power to exercise an authority, you should be able to exercise that authority again and again. So it is not only for one time the authority is given, authority is available to you for all situations which is coming to you. Similarly, there is some power which gives you to appoint power to appoint ex officio. So you can appoint anybody ex officio, that means on the chair, basically. On ex officio means it is by virtue of the office. Like if I say I'm the dean of the faculty, dean's position is an ex officio position. Head of the department position is an ex officio position. This is not a named position. These are ex officio positions. So power to appoint will also include power to remove or suspend. This is section 16. And substitution of functionaries. So authority may direct, or authority may say that, okay, fine, in your place, somebody else will be working. Like, for example, if one HOD goes on leave, then another would be substituting that function. If the collector is on leave, then deputy collector probably is given charge of that. If chief minister is on leave, deputy chief minister may exercise the authority. Then section 18 talks about successors. So government, if you will see, doesn't paralyze, it always has somebody to take the chair, somebody to take into account. Like, for example, if you are having, if there is no chief minister or if there is some challenge in the state government, governor takes over, okay? And governor has got the power. If governor is not there, president takes over, like that. So these powers and functionaries are having a well-oiled mechanism, and that is supported by way of legislation. Because if law is not there, probably that can be challenged in courts, and it will be becoming difficult for them to work. And hence, they are providing these provisions very, very clearly. So as you can see here in this particular case, we are talking about the powers and functionaries under section 14 to 19. So these provisions basically are meant to underline the administrative flexibility and continuity embedded in statutory frameworks. They are designed to address issues related to succession, delegation, and maintenance of authority within various levels of functionaries, and it ensures the smooth governance of the government. So let us take an example and try to understand this in a more better and nuanced way. So if you will see, let us look at the municipal corporation. Okay, so the municipal corporation is tasked with managing urban development and enforcing regulations, as well as for maintaining civic amenities. Okay, so now the municipal commissioner is the chief executive officer of the municipality or the municipal corporation. Now, section 14 talks about power conferred to be exercised from time to time. So what does this mean? Here, the municipal commissioner is empowered to levy fines for illegal construction. Now, these fines are not a one-time imposition. So here, whenever the municipal commissioner will find that there is an unauthorized construction, they can levy a fine. And whenever there will be a violation occurring, they can do it. They can remove the unauthorized structures in different parts of the city. I think you people may be now noticing that multiple places now municipal commissioners have become very active and they are removing the unauthorized construction. Either it may be Delhi or Gurugram or maybe in Uttar Pradesh or West Bengal or many other places. The municipal commissioners are doing this particular activity. So this is not a one-time power. This power vests with the office and they can give order from time to time. This is what section 14 talks about it. So once a power is given, that power is exercisable from time to time depending upon the situation. So each time they don't require an order from the government to take a decision, because this is by virtue of their office. They have got the power to take decisions and give orders. So I hope you got this particular point with clarity. Now, let us look at this particular situation and move further and talk about section 15. Section 15 talks about power to appoint, includes power to appoint ex officio. So here, if you see, the municipal commissioner appoints an officer as the head of the health department. Okay. Now here, by virtue of this position, the appointee automatically becomes an ex officio member of the municipal disaster management committee, ensuring the health perspective is considered in disaster planning. So there are multiple, offices which has got ex officio appointments. So every time there is no need, like for example, you will see at the central government level, there are many offices where leader of opposition is an ex officio member of that committee. Like many appointments, like for example, appointment of the chief election commissioner or appointment of the CAG, all these positions, LOP, that is leader of opposition, is the ex officio member. So now every time they don't require a named appointment. So as soon as the leader of opposition is named once, then they will become ex officio member in all the positions wherever this ex officio position is referred to. Like for example, I can give you in my office, I am the dean. So in the university statute, dean is an ex officio member of the academic council. So I will always be part of the academic council, or in my place, if somebody else is their dean, they will be part of the academic council by virtue of this ex officio position. So power to appoint include power to appoint ex officio. So a person who takes the chair also takes the ex officio chairs. I hope this gives you the explanation clearly. Are you able to understand this? Can you give a heads up? All of you, these 14 and 15, is it clear? Yes, Sushmita, you are not able to understand. Have you understood now? I gave you the example, ex officio, LOP. Okay, let me explain again. So, see, ex officio, I'm explaining. Okay. So, if you are appointed, like say, for example, there is a municipal body or there is a body which requires members. I don't know how many of you have been part of the student council. So in the student council, there are ex officio position. Okay. So ex officio position is like by virtue of your place, you are appointed. Like say, for example, if student council says that every um, class representative or every class representative is part of the student council. So as soon as a class representative is nominated, they become the ex officio position automatically as soon as a person gets appointed. Okay. Sushmita, I think you have got it very, very correct. Yes, that is how it is. If dean is appointed, then if any other act gives preference to dean, then the person will be default have to the act accordance. So they will be automatically taking that position. Let me give you that LOP example again. Like if you see the disaster management authority of each state has mandatorily the chief minister of that particular state as the chair. Okay. State Disaster Management Authority. And in National Disaster Management Authority, it is the prime minister. So as soon as in West Bengal, you saw the chief minister changed. As soon as Mr. Subhendu Adhikari took charge as the chief minister, he was not required to be appointed as the disaster management authority head. He automatically became the head of the disaster management authority of the state. Why? By virtue of the law itself. So it is saying power to appoint include power to appoint ex officio. So when the governor or when the president or when the governor appointed him to the position of the chief minister, automatically he also got the appointed to all his ex officio positions. I hope this is clear to you people. Yeah. In case you have not understood, I'll explain again. Okay. If you have understood, let me proceed further. Then we are talking about section 16. So section 16 says power to appoint to include power to suspend or dismiss. So here the commissioner who has appointed sanitary inspectors to enforce cleanliness and waste management also suspends one inspector for neglecting duties, such as failing to address persistent garbage collection complaints in a key residential area. So this is a basic norm that person who gets the power to appoint also has a power to dismiss the person concerned. So this is suspend or dismiss the person concerned. This is a very important provision. So whosoever has got the power to appoint can remove the person also. That power is also there with that particular person. However, a statute may, mention it otherwise also. Like, for example, appointment of judges. Now, appointment of judges is by way of president, but president cannot remove the judges, right? So, judges can be only removed in situations which are mentioned in the constitution, which is by way of impeachment, and that is a long process. So, just because president appoints, similarly, they cannot be removed. So, this is a specific, but in general situations, in general administrative situations, particularly for the working staff or similar kind of a situation, the person who has got the power to appoint has also got the power to dismiss. This is what section 16 says. Okay, now let us move ahead. Section 17. Section 17 says substitution of functionaries, and it says if the commissioner is on long medical leave, the deputy commissioner steps in to exercise the commissioner's statutory power, such as approving urban development plans and issuing licenses until the commissioner resumes duty. Now, this is substitution of functionaries is very important because anybody can be, fall ill or is incapacitated or because of X or Y reasons, they are not in the office. So there has to be some junior who will take over that particular responsibility for that period, and administration should work smoothly. So you cannot say that नहीं साहब छुट्टी पे गए हुए हैं तो काम ही नहीं हो रहा है, right? So there has to be some sahab below the main sahab who will be doing the particular work. And this is what section 17 talks about it. However, here you will have to understand that there are certain functions which cannot be delegated, which cannot be given to the junior, right? So some functions are very, very important functions, and that has to be exercised only by the higher authorities. In those situations, the arrangement has to be made in the administration. But in normal circumstances, in normal situations, there will be a substitution of functionaries, right? Let us move ahead and talk about successors. Okay, Daksh, what is your question? What if there is not any appointment of some junior still? Okay, if there is no junior to whom it can be delegated, then there has to be someone who, then there may be some additional subordinate offices. Like, for example, additional charge is given to another vice chancellor to take care of it, of an institution, if one vice chancellor is not there or there are no junior people available in there, right? Now let us talk about successors. So section 18 of the act talks about successors, and it says when the current commissioner retires, the newly appointed commissioner immediately inherits all powers and responsibilities without requiring any formal transfer. This ensures that governance and administrative functions like addressing encroachments or approval budget allocations remain uninterrupted. And I can give you a beautiful example of this successor thing because recently in the political turmoil, this came up. And you saw the situation in West Bengal, right? The former chief minister made a statement that, yes, I'm not going to resign. Now, there was a stalemate in between. There were some people who were asking what will happen, how the things will work. So General Clauses Act Section 18 has got an answer very, very clearly. Though Constitution has also got the answer, but this particular provision very, very clearly says in terms of, so anyone who leaves the office, automatically that particular official, whatever situations, whatever responsibilities, duties, powers, everything automatically gets transferred to the new person, and they start working from that there on. So there is no need for any formal appointment. There is no need for any formal taking over or something like that, but automatically things work. So this is by way of Section 18 of the General Clauses Act. I hope you got the clarity on this. So you can see, irrespective of the government, irrespective of the political parties, the government keeps on functioning, right? So one person keeps coming, another person keeps going. So there is a continuity which is maintained because of these provisions. Now let us talk about another section, and that is section 19, which talks about officials, chiefs, and subordinates. So the chief engineer of the corporation delegates responsibility to assistant engineer to supervise the construction of drainage system in various zones of the city. While the chief retains overall accountability, subordinates carried out day-to-day operational tasks within their specific jurisdictions. So there is a power with the seniors to delegate certain tasks to the juniors, because senior cannot be at every place. And if you would recollect my second or third slide in my previous lecture, wherein we discussed about the power of CMM, Chief Metropolitan Magistrate or District Magistrate, in case of SARFACI, wherein they can appoint advocate commissioners. So this is basically official chiefs and subordinates. So this helps in better functioning, because the chief cannot go everywhere. So he appoints or he delegates his certain tasks to people, and that is protected under Section 19 of the General Clauses Act. So I hope this makes the things clear to you people. So this example basically demonstrates how these principles work together to create a robust framework for governance, and it ensures that powers are exercised effectively, delegated appropriately, and they are seamlessly transitioned or substituted in the case of changes in personal or unforeseen circumstances. So these are the provisions. If you have a look at it again, these are the sections. So if you read the sections, the explanations I gave you in detail. So if you want to read the sections, you can read it. Whereby any central act, regulation made after the commencement of this act, any power is conferred, then unless different intention appears, that power may be exercised from time to time as occasion requires, right? Similarly, for power to appoint to include power to appoint ex officio, where by any central act or regulation, a power to appoint any person to fill any office, execute any function is conferred, then unless it is otherwise expressly provided, any such appointment, if it is made after the commencement of this act, may be made either by name or by virtue of the office. That it can happen. Likewise, there are different sections. I would request you to read these sections and ask me any question you have on any of them. Daksh, I have been sharing all these PPT on your LMS, I think the learning management system or portal. I'm sharing there as a PDF. Yesterday, I have already shared. Today is also it will be shared. And for General Clauses Act, I have a set of questions which are from the previous question banks. So that PDF also I will share it with you, so that you can practice those questions. However, all those questions I have also included in the PPT, but still, if you want to see only questions, you can refer to that. Yes, go through this particular sections one by one. And I think we are at our break time. So I leave this particular slide for you during the break. Please read all these particular sections in detail. And if you have any questions, you can come back after the break. We meet again at 7:30. We are taking a 15 minutes break. And if you have any clarification, I will be happy to help you. If you don't have any clarification, we will proceed with the further sections. As I explained you, the powers and functions of these provisions, idea is basically to support the administration and run it clearly. Someone has asked about section 14. So if you section 14, Achal, is basically the situation which says that power, if conferred to an authority, is exercisable on every occasion. So for each occasion, you don't require a specific permission. You have to, there's only one time a permission is given. So it says, you can read section 14. It says, whereby any central act, regulation made after the commencement of this act, any power is conferred, then unless different intention appears, that power may be exercised from time to time as occasion requires. So if a collector is appointed and collector is given a power to run the district administration, they don't require on every occasion a order from their seniors, chief secretary or someone. As district magistrate, he has got certain powers. And whenever there is a requirement of exercise of those powers, he can exercise as district magistrate. Similarly, these are powers given to different offices. Like if the office of the dean has a power that they can exercise, whenever the occasion arises, every time they don't have to go to the vice chancellor for taking approval. I hope you get this particular point. Okay. Now, let us move further and talk about these we have discussed already with an example from the municipal corporation. Now, let us look at this question. Since you have already studied, now can you respond to this question? Read it and respond. So, Dream Builders Limited was engaged in the activity of building and selling budget-friendly apartments. It recently started a new project at Noida. Pending approval, the builders started the construction work. On verification of documents, the Corporation of Noida refused to sanction the permission, and the Assistant Commissioner, Mr. S, issued a demolition order signed by him under his authority. Now, the builder filed an appeal at the court and stayed the demolition. After 6 months, the court trials, the verdict was announced in favor of Corporation of Noida. Mr. G, the present Assistant Commissioner, initiated the demolition process. Now, builder is arguing that the order was passed by Mr. S, and since he is no longer in the authority, the order stands cancelled and Mr. G cannot demolish the construction. Now, referring to the provisions of General Clauses Act, determine the validity of the claim of the builder. What would be your answer? Refer to the relevant provision and try to explain. Let me see how you people explain. Which provisions will apply which one? 14 to 19, which one will apply? And how you will apply that? Yes, Vishaka, you can give the further explanation as per section 17 what? Okay. Waiting for some more responses. I think we are having more than 17, 18 students in the class. Yeah. Go ahead. Okay, Vishaka, but what is the section? Which section? Sushmita says section 18. We are having one response, Vishakha saying section 17. Sridhar says section 15. Well, that's quite interesting. You people are having so many sections. So what it is talking about? The question is here the continuity, right? So it says that irrespective of the person leaves the office, right? I gave you the Mamta Banerjee example in one. So that will be builder argument is incorrect. But tell me what is the provision, Anil? Okay, I will put this point to rest, and you can see here this is the answer. So 17 and 18, these are the two provisions which will be applicable in this situation. And you can see here what it is. As per section 17, in any central act made after the commencement of it shall be sufficient for the purpose of indicating the application of law to every person or number of persons for the time being executing the functions of an office, to mention the official title of the officer at present executing the functions, or that of the officer by whom the functions are commonly executed. As per section 18, it shall be sufficient for the purpose of indicating the relation to law of the successor. So basically, successor law will apply. So whosoever succeeds a particular office will also continue with whatever orders have been given in that particular point in time, right? So as per the facts of the question and a combined reading of section 17 and 18 of General Causes Act, Mr. G, in his capacity as the current Assistant Commissioner, is legally competent to order the demolition of construction. This is because the original order was issued by Mr. S, the then former Assistant Commissioner, in his official capacity, and the authority to act continues with the office, not the individual. Hence, the claim of the Dream Builders Limited is not valid. I hope this example gives you clarity on power and functions of authorities, right? So as you could see, though provisions are looking very simple, but it is confusing, okay? So you need to read them one by one in sequence and try to understand it. Is it clear till this point? Shall we move further? Okay. Now let us look at the provisions as to orders, rules, etc. made under the enactments. So this provision is basically talking about construction of orders, etc. issued under enactments. That is section 20. Section 21 talks about power to issue to include power to add, to amend, vary or rescind notifications, orders, rules or bylaws. Section 22 talks about making of rules or bylaws and issuing of orders between passing and commencement of enactment, and provisions applicable to making of rules or bylaws after previous publication. And 24 talks about continuation of orders, etc. Now we'll move with each of these sections one by one. So the first one is construction of orders, etc. issued under enactments. So what the provision is saying? Provision is saying whereby any central act or regulation a power to issue any notification, order, scheme, rule, form, or bylaw. So these are the different terms used for order. Okay. So authority have got these powers. And if you recollect under Article 13 of the Constitution of India, these are all laws, by the way. Okay. So central government, by way of a regulation, this can give power to different authorities to issue notification, order, scheme or so. Then expression used in the notification, order, scheme, rule, form or bylaw, if it is made after the commencement of this act, unless there is anything repugnant to the subject or context, have the same respective meanings in the act or regulation conferring the power. It is basically saying that if you are deriving the power from a act, the notification will be meaning the same things as it is mentioned in the act. Basically, what it is saying that your notification by any authority cannot go beyond a particular legislation, right? Let us look at this example. This will make it more clear to you. So it is saying the term collector used in Rule 4 of the Land acquisition, section 3C of the Land Acquisition Act. So if the land acquisition rules is referring to collector, which is defined in Land Acquisition Act, it will have the same meaning. Like I can give you an example under the Companies Act. So Companies Act defines director. So if you are looking at the company's management rules, the definition of director cannot go beyond the definition which is given under the Companies Act. So you have to refer to the Parent Act. Your definitions or your meaning of a concept under the rules, regulations, notification, bylaw cannot go beyond what is defined in the Parent Act. I hope this is making sense to you people. So in the case of Subhash Ram Kumar versus State of Maharashtra, it was held that notification in common English acceptation means an implies of law. It is a formal declaration instructions. There has to be a clear notification. So in this provision, it is, saying that there has to be specificity. You cannot, give a general direction without any order or this. So there has to be everything which has to be in a written format and properly defined and as per the act, not beyond that particular act. Is it clear to you people, this section? Or you want any more example? I can give you another example if you want. Yeah. Is it clear? Section 20. Have you got it? Or should I give you another example? I hope it is clear, right? So it is basically saying that you cannot go beyond the meaning which is given under the Parent Act. Any rules, regulations, notifications issued by the authority has to comply with the main act. Like, for example, if you are looking at company rules, then you have to refer to the Companies Act. Like, let us take another example. Okay, Karishma. So you have IBC, Insolvency and Bankruptcy Code, and it defines operational creditor and financial creditor. Now, if you say, for example, or maybe there is an order by IBBI or maybe the Institute of Chartered Accountants of India, which governs the insolvency professionals, they come up with a notification. This notification cannot go beyond IBC. So whatever they define, whatever they make an order, has to confirm or has to comply with the requirement under the Insolvency and Bankruptcy Code, right? So this is what this section is saying. So whenever you are trying to make a meaning of a notification, scheme, rule, or bylaw, you are referring to the Parent Act. It cannot go beyond the Parent Act. Is it clear now, Karishma? Yes. So any notification, order, scheme, rule, bylaw cannot go beyond the Parent Act. Correct. Now let us move ahead and talk about the next section. That is section 21. Section 21 talks about power to issue to include power to add, to amend or vary resigned notification orders rules. So this basically is talking about the scope of the power. So where any central act or regulation gives a power to issue notification, order, rules, or bylaws to any authority, that power would also include to add to that notification, to amend that notification, to vary that notification, and to also rescind that notification so issued by the authority. So if IBBI is given a power to make a regulation, it has also got the power to amend that regulation, to repeal that regulation, to rescind that regulation. Okay. This is what is a plain and simple meaning of section 21. So in Rasid Javed versus State of Uttar Pradesh, Supreme Court said that section 21 of the Act, an authority which has power to issue a notification has the undoubted power to rescind or modify the notification in the like manner. Similarly, in Sri Siddhibali Steels versus State of Uttar Pradesh, Supreme Court again held that power under section 21 of the Act is not so limited as to be exercised only once. Power can be exercised from time to time, having regard to the exigency of the time or situation. This is also in line with section 14 of the General Clauses Act, wherein we have said that a power given to an authority, they can exercise that power again and again. So this power is with reference to making rules. That power was a general power of taking actions. Is it clear? Section 21, is it clear? Daksh. So resigned basically means to repeal or to remove. That is called resign. Resigned means to delete, to remove. Okay. Now let us look at another section, and this section is 22, and it says making of rules or bylaws and issuing of orders between passing and commencement of enactment. So this you would recollect when we were discussing about the act. I told you that the act may commence on the day when it is passed by the president, or it can commence in coming years or coming days. I gave you example of DPDP rules, which is coming into effect in 3 phases, right? 13th November 2025, it came into force, some portion. Certain portions will be coming by 13th November 2026. And finally, 13th May 2027. So this clause, this section is referring to the period between 13th November 2025 to 13th May 2027. What happens in between this period, right? So it is saying that where by any central act or regulation, which is not to come into force immediately on the passing thereof, a power is conferred to make rules or bylaws or to issue orders with respect to the application of the act or regulation, or with respect to establishment of any court or office or appointment of any judge or officer thereunder, or with respect to the person by whom or the time or place where or manner in which or fees for which anything is to be done under the act or regulation, then that power may be exercised at any time after the passing of the act or regulation. But rules, bylaws, or orders so made or issued shall not take effect till the commencement of the act or regulation. This is quite an interesting provision. I can give you a background of this provision, section 22. Okay. So let me give you an example of Competition Act. So when Competition Act came into force, when Competition Act got the assent of the president, it was 2023, December 2023, if I'm not wrong, 13th December 2023. The Competition Act was given, president gave the assent. But immediately provisions were not notified. However, the rules and regulations have to be made. Someone has to make the rules and regulations. So there was a commission which was notified by the government, and the commission started making the rules and regulations, bylaws, orders, draft. They started discussing it. So these things can be done, but those rules, regulations, and everything will come into force only when the act gets notified, not before that. Okay. So for about 6-7 years, they were making these rules, regulations, and it took some time for Competition Act to be notified. It was only in 20th May 2009 that the law got notified. Same is the case with Mediation Act. If you have a look at it, Mediation Act has been passed, and it is talking about Mediation Council of India and many other things. So those rules, regulations, and every paraphernalia is getting work, but it is not yet notified, right? So this is how the law is talking about. It is making a provision for making rules, regulations, but it cannot come into force unless the government notifies it. Okay. So let us take this example. Suppose Parliament passes the Digital Data Protection Act on 1st July 2026. By the way, they have passed this legislation on 13th November 2025. But the act is scheduled to come into force on 1st January 2027. This is a hypothetical situation. Now, the act authorizes the central government to establish a data protection board, appoint its chairperson and members, and frame procedural rules. Now, as per Section 22 of the General Clauses Act, what things government can do? Government can appoint a chairperson and members in August 2026. Government may frame the procedural rules in September 2026. However, they cannot exercise the statutory powers until 1st January 2027 when the act comes into force. So if they have to make any statutory power exercise, they have to wait till the law comes into force, while the whole paraphernalia will be there very much in existence. What is the rationale for this provision? Rationale for this provision is that it takes care of the situation between coming up of the act and its enforcement mechanism. Because whenever a law is passed, immediately it may not get enforced. It requires a lot of things to be done for that law to get into force. Like, for example, we have Women Reservation Bill, right? The Nari Vandan Adhiniyam. Now, the law has been passed, but it requires many things to be done before the law can get into force. So these are These are the things which will be taken care of by Section 22 of the General Clauses Act. So I have already given you the example of Competition Act and Mediation Act. Any question on this Section 22? Any one of you? Okay, I think it is clear. Okay, now let us move further. Section 23 talks about provisions applicable to making of rules or bylaws after previous publication. This is a very important provision, and it tells that whenever you are making rules, bylaws, regulations, you do some public consultation. This is what this law says. So it's saying whereby any central act or regulation, a power to make rules or bylaws is expressed to be given subject to the condition of rules or bylaws being made after previous publication, then the following provisions shall apply. So wherever there is a requirement of previous publication for regulations, these provisions will apply. So what are you saying? The first thing is that the authority having the power to make the rules shall, before making them, publish a draft of the proposed rules or bylaws for the information of persons likely to be affected thereby. So there will be a notice given to people who are getting affected. Then the publication shall be made in such manner as the authority deems fit. Generally, this is in the official gazette or the website or newspaper, like that they make the publication. Third, there shall be published with the draft a notice specifying date on which the draft will be taken into consideration. Then the authority having the power to make rules or bylaws, where the rules are made with the sanction, then the authority shall also consider any objection, suggestion which they have received from the people. And then the publication in the official gazette of a rule or bylaw purporting to have been made in exercise, and any previous publication shall be the conclusive proof that the rule or bylaw has been duly made. So let me give you an example. So this is an example of the draft rules which were published under the DPDP Act. So you can see here, they published this and they have given a notice to the public that if there are any objections or suggestions, you can give it to this particular rule. So this is best practice in legislative drafting, where before making the rules, they release it to public, and any public who has got comment inputs, they can give the inputs, and those inputs are considered by the committee, and whatever is accepted, rejected, that they give it in the report. So this is a requirement as per the provisions of Section 23. I hope this provision gets clarity to you people. Any question on this? There may be many legislation in which such kind of a procedure is followed. Now, making of rules which is getting affected, or people are getting affected. Okay. Yeah, I think you have no questions. Now let us move ahead to Section 24. So Section 24 talks about continuation of orders issued under enactments repealed and re-enacted. So it is talking about a situation that if the law gets repealed and then re-enacted, what happens to the orders which has been passed in the previous law? Let me explain you by way of an example. So this is an example under Section 24. So first we will see. So let us suppose that there is a law called State Education Services Act 2000, and it governs the appointment of teachers. And under this act, the government issues recruitment rules 2005. Okay. An appointment notification for teachers, promotion scheme for lecturers. However, later the act is repealed and re-enacted as State Education Services Act of 2025. So there was a law in 2000. Under the law, there were rules made, recruitment and promotion rules for teachers. Later, the law got repealed and reenacted as the new law, that is State Education Services Act. Now the new act is largely similar, but reorganized and modernized. Like, for example, you have got Bharatiya Nyaya Sanhita in place of Indian Penal Code. Now, what happens to the existing rules and orders? So, recruitment rules of 2005, what happens to that? This is the question which Section 24 answers. So, under Section 24, the 2005 recruitment rules, that is the existing appointment notifications and promotion schemes, will not automatically lapse. They will continue unless the State Education Services Act specifically mentions that whatever has been done before will be repealed, then it will get repealed. There will not be any automatic lapse. So they will continue to operate, be treated as if made under the 2025 Act, and they will remain valid until replaced or inconsistent with the new law. If the law says specifically that recruitment rules of 2005 will be repealed, it will get repealed. I hope this gives you clarity on Section 24. So I'm not reading this Section 24 because it will become more confusing. I have given you the essence of the law. By the way, nowadays, all legislation provides the mechanism to deal with the repeal and saving provision. Like if you look at Section 66 of the Competition Act, it clearly lays down what happens to the cases which were pending. So for your information, I think you people may be aware that Competition Act replaced the earlier Monopolistic and Restrictive Trade Practices Commission, that is MRTP Commission. Okay. So repeal and saving law made clearly the mechanism that which cases will go where. Like it says specifically that all the cases relating to unfair trade practices will be going to the Consumer National Commission. And any pending matter before the Director General IR will be going to the Competition Commission. Any matter after complete investigation pending on monopolies or something will go to the National Company Law, Competition Appellate Tribunal. Like this, these mechanisms are clearly mentioned in repeal and saving. If these mechanisms are mentioned, they will have precedence. The law will work according to that. If there is nothing mentioned like that, then those things will be continuing. So this is what the Section 24 says. Is it having clarity to you? Have you got the clarity on this, Section 24? If you have not got the clarity, I will explain again. Yes. Have you understood Section 24? Okay. Let us now move ahead with Section 25 to 30. These are miscellaneous provisions and they talk about recovery of fines, provision as to offenses punishable under 2 or more enactments, meaning of service by post, citation of enactments, saving for previous enactments, rules and bylaws, and application of Act 2 ordinance. Okay. Now, if you see the first one, that is recovery of fines. So it is talking about a situation where fines have to be recovered. So there are a number of provisions, civil as well as criminal. There are fines which can be imposed. So it is referring to Section 63 to 70 of Indian Penal Code. By the way, Indian Penal Code now has been repealed and all the provisions which were there under Section 63 to 70 of Indian Penal Code is now covered under Section 8 of BNS. In essence, I will explain you. I cannot explain you in detail about Section 8, but it says that wherever there is a civil penalty imposed, in civil cases, whenever there is a civil penalty imposed, that you have to pay a fine of rupees maybe 50,000, 10,000, 5,000, whatever. And the question is, if, say, for example, the person doesn't pay the fine, what happens? Can you tell me? Say there is a imposition of penalty that, okay, fine, you have done the mistake and hereby you are given 10,000 fine. If you don't pay the fine, what will happen? Okay, good. So there will be imprisonment. The penalties they are not paying, right? So fine gets increases. That can be one option. But IPC, Indian Penal Code or Section 8 of BNS clearly says that if there is a fine which is imposed by the court and they are not able to pay it, in lieu of fine, there can be civil imprisonment. So this is Section 8 providing that. And provisions of criminal procedure code will be applicable in relation to the issue and execution of warrants, levy of fines imposed under any rule by law, and express provision to the contrary. So this is what it is trying to say, right? So section 25 deals with that. Section 26 says provisions as to offenses punishable under two or more enactments. And this brings forward a very famous principle under the Constitution, and that is called rule against double jeopardy. So, where an act or omission constitutes an offense under two or more enactments, then the offender shall be liable to be prosecuted and punished under either of those enactments, but shall not be liable to be punished twice for the same offense. So, this is basically, for protection of the accused. You cannot prosecute one person for the same offense twice. This is what is called rule against double jeopardy. So Article 22 of the Constitution states that no person shall be prosecuted and punished for the same offense more than once. So in state of MP versus AVR Agnihotri, it was held that when there are two alternative charges in the same trial, example section 409 of IPC and section 52 of the Prevention of Corruption Act, the fact that the accused is acquitted of one of the charges will not bar his conviction on the other. So you can see here, it is basically trying to say that same set of facts can violate two different laws. Then in that situation, there will be, prosecution under both the laws, and there can be concurrent sentences or consecutive sentences running in those situations. But they cannot be prosecuted for the same offense, in the same transaction twice. That is what it is trying to say. Let us look at this question and then it will be making it more clearer to you. I'm looking forward to your answer. So here this is the situation. Mr. N is caught stealing a bicycle, an offense punishable under the Indian Penal Code. Okay. So according to section 379 of IPC, the punishment for theft was charged against him. Now elaborate how term imprisonment levied under General Clauses Act can be applied in line with the relevant law specified in the IPC. Yes. Can you answer this? Yeah. Go ahead. Basically, this is not with reference to section 25. This is with reference to section 327 of the General Clauses Act, wherein imprisonment has been defined. So it says imprisonment shall mean imprisonment of either description as defined under IPC. By section 53 of the IPC, the punishment to which offender is liable under the code are imprisonment, which is of two description, namely rigorous imprisonment or simple imprisonment. So when an act provides that an offense is punishable with imprisonment, the court may, in its discretion, make imprisonment rigorous or simple. In this case, if the court considers Mr. N offense as minor theft and believes it does not warrant harsh punishment, it may sentence him to simple imprisonment. However, if theft involved force or was committed in a violent manner, then, or there is a history of criminal behavior of Mr. N, they may decide to impose a rigorous imprisonment. And that is why there is a discretion given to the criminal courts in terms of imposition of the punishments. Let me talk about this. Read this. The Parliament recently passed the Environmental Protection Act to strengthen regulation on industrial waste disposal. The Act specified the commencement date as 1st September 2024. The President gave assent to the Act on 15th July 2024. Now, Green Earth Limited, an industrial company, is uncertain about when the provisions of the Environmental Protection Act will start to apply. The company's legal team has raised question on whether they need to immediately comply with the new regulations or if they have a grace period until the commencement date. Can you give your answer with reference to General Clauses Act? Yes. This law will start commencing. Okay. Sushmita says act will commence when it comes into force. Can you tell me the date here? 1st September. Okay. Good. So the act shall commence from 1st September 2024, not from the assent of the president. This is what it is. There is a statement saying no person shall be prosecuted and punished for the same offense more than once. Explain in light of the provisions of the General Clauses Act. Can you explain? Which provision talks about it? General Clauses Act. Just now we discussed. Section 26. Okay. Section 26 of the General Clauses Act says that, and which article of the Constitution refers to it, and what is the term used for it under the Constitution? Article 22. Good answer. And what is the term used for it? Right against? No, right against double jeopardy. Okay. So we have used the term double jeopardy. Right against double jeopardy. So in simple, it is saying no person shall be prosecuted and punished for the same offense more than once, means right against double jeopardy. So section 26 of the General Causes Act, it says where an act or omission constitutes an offense under two or more enactments, then the offender shall be liable to be prosecuted and punished under either of them, those enactments, but shall not be punished twice for the same offense. Right? So Article 22 says that. Okay. Read this and give me the answer. So the Apex Manufacturing is an industrial company based in India. Recently, the company found itself embroiled in legal issues concerning two separate offenses under different enactments. The first offense involved a violation of environmental regulation for which the company was prosecuted and fined. Subsequently, Apex Manufacturing was charged under a different law for a similar but not identical environmental violation. The first offense was under Environmental Protection Act 1986 for failing to dispose of hazardous waste properly, and second offense under the Water Prevention Control Act involved in the discharging of untreated wastewater into the river. Now, Mr. Sharma, the company's legal advisor, consulted on said issue. He determined the prosecution outlined in Section 26 of the General Clauses Act and Article 22 of the Constitution of India, which protects against double jeopardy. Comment upon the validity of the protection that can be given to the Apex Manufacturing. Yeah. Can they be given? What is your answer? Option D. Okay. We have got two answers. Option D. Someone has answered answer C. Okay. Few more options would like to give. Okay. The answer is option B, which says not valid because the specific actions and legal provisions violated are different in this situation, right? Not the same. So there is a Water Prevention and Control Pollution Act is different law, and air pollution is a different law. So these are the two different. Solid waste is a different, and second is one is under Environmental Protection Act and the other one is under Water Prevention and Control Pollution Act. These are the two different violations, and hence double jeopardy does not apply in this situation. Okay, let us look at this particular section. This question. Which one would be the answer? Enactment basically is law. Enactment means different laws, different enactment. Okay, Daksh? So when I am saying Environmental Protection Act and Water Pollution Act, these are two different enactments. Like for example, in this example, you can see Indian Penal Code and Companies Act. These are two different enactments. Read this particular provision, this question. A company enters into process of reducing capital and Mr. Shah is concerned officer designated for preparing the list of creditor to record their reservation and reach to a settlement under Section 66 of the Companies Act. Mr. Shah, while preparing such list, deliberately concealed the name of Mr. Ramya, who is one of the company's creditor and object to the reduction. The offense committed by Mr. Shah is punishable under Section 447 of the Companies Act. This is corporate fraud. And also under Section 417, read with 415 of the Indian Penal Code. As dismissed, you are required to select most appropriate option out of the given below. What is the option you have selected? I got two options, C and A, as an answer. What is your answer? Few people, you may like to give the answer. C, D, okay. B, I got all options now. A, B, C, D, everybody. One of you have given one answer, another one. Okay. Answer here is C. So Mr. Shah shall be liable to be prosecuted and punished under either the Companies Act or the Indian Penal Code 1860. Right? Because it is same, both action is same, right? Same thing, you cannot punish him twice. So you cannot punish him for the same offense under Section 447 as well as under 417. Either of you have to choose either of them because there are no different offenses. They are same offenses under two different acts. So that is the difference between these two. In the previous section, previous question we have seen here, there are two different acts and two different violations. So you cannot choose between them, right? Environmental Protection Act is a different legislation. Water Prevention and Control is a different legislation. So Environmental Act talks about failing to dispose of waste properly and Water talks about discharging of untreated wastewater into the river. So these are two different laws, different regulations. Okay. Let us now talk about 27. This is talking about service by post. Service by post is a definition given and it says where any central or regulation, act or regulation made after the commencement of this act authorize or requires any document to be served by post, whether the expression serve or either by expression give or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying, and posting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would have been delivered in the ordinary course of the post. It is quite interesting, you know. So many a times you would have seen that letter or notice is given and notice comes to you and you say that I don't accept the notice, I don't take the notice. Legally, you have already taken the notice. There is no need. You deny, it doesn't matter. Because law says that if I have, created a letter, notice, written the clear address of the notice of the recipient and made it with a registered post, that registered post acknowledgement due will be considered as a sufficient notice or service by post. Okay. So this is a law's requirement. Otherwise, people will be evading notice and then the case cannot go ever. So Code of Civil Procedure CPC Order 5 talks about several modes of service. So in civil cases, the service is determined by Civil Procedure Code Order 5. So it says provide several modes of service. And it says in United Commercial Bank versus Bhimsen Makhija, A notice when required under the statutory rules to be sent by registered post acknowledgement due is instead sent by registered post only. The protection of presumption regarding service of notice under registered post under this section of the Act neither tenable nor based in the sound exposition of law. So when it is saying registered post acknowledgement due, there is a legal requirement of the postman to take signature of the person concerned to whom the letter is delivered, or he will also make an endorsement that letter is denied or the person is not present there. So if you send it by ordinary post, it will not be considered as a proper service. If it is registered post, then only it will be considered as a proper service. Now, I don't know what about courier, whether courier is considered here. So, Jagdish Singh versus Nattu Singh, it was held that where a notice is sent to the landlord by registered post and the same is returned by the tenant with an endorsement of refusal, it will be presumed that notice has been served. So, refusal will not count. Similarly, in another case, Srimati Vandana Gulati versus Gurmeet Singh, it was held that where notice sent by registered post to person concerned at proper address is deemed to be served upon him in due course unless contrary is proved. Endorsement not claimed, not met is sufficient to prove deemed service of notice, right? So this is how the service of notice happens. There is an interesting situation which I want to discuss with you, but before that, if you can look at this particular question and then we discuss. Can you read? All of you, please read this. And what is your response? If a person fails to receive Aanchal, then that will be considered as service. If they don't take it, they return it, then that will be service. So it is always better to receive a notice rather than ignoring it. Yes, have you gone through it? Mr. Rachit is absolutely wrong as deemed to be notice served. Okay. Anybody else? Okay, good. So this is what is the situation. Here you can see the provision is section 27. You people all know. So what was the conclusion? On the basis of our, it can be said that sending of notice by the income tax department was properly addressing and a registered post was proper service of notice. it was the duty of Mr. Rachit to update his address. Therefore, income tax department is correct in his decision. Okay. So that is why it is important that in all places, your official places, your address should be properly updated, right? I was talking to you about another interesting situation, that is service by WhatsApp or email. So can there be a service by WhatsApp or email? Now, this is a gray area. It is not very clear, and this is not part of your syllabus also. I just curiosity, because nowadays we all are using WhatsApp and email, and you get a notice on WhatsApp, what happens to that? So there is clarity here that if it is a civil case, so likely your WhatsApp notice or email notice will be considered as a proper notice, as held by Bombay High Court and Delhi High Court in the case of, Cross Television and Tata Sons. So generally, WhatsApp service will be becoming a service in case of civil suit, commercial courts, debt recovery, etc. However, if it is a matter relating to criminal law, then there it was recently held in Satyendra Kumar Antil's case 2025 by the Supreme Court of India that WhatsApp notice or any other electronic form notice cannot be considered as a proper notice under the Bharatiya Nagrik Suraksha Sanhita, that is Criminal Procedure Code, because criminal law is a more stern law, so it requires a physical service. The accused must be served properly, as per the summons should be served to the accused, and that is very important. So this is the difference between the civil and criminal law service. You would like to read more on this particular dimension, you can refer to Vidhi Legal Policy Service of Summons article. Any question on this? Any one of you? Any question or any more clarity needed on the service? Go ahead, Daksh. I could not understand your question. Okay. In the meantime, I will move ahead with section 28. So section 28 talks about citation of enactments. So it says that wherever there is a central act or rule or bylaw or instrument or document, enactment may be cited by reference to the title, short title, conferment. So basically, it is trying to say that how you are going to refer to the act or enactment or subsection, how you are going to refer to it. So I've given you the example, like if you have to cite the section, then you will say the provisions of section so and so are relevant to corporate restructuring. So you will say, Companies Act section, the provision of section 5. If it is a general citation, you say in terms of Rule 12 of the Income Tax Act rules, this cites rule made under the income tax. Now, when you want to incorporate a provision, so you say as per section 40 of the Consumer Protection Act, the terms outlined in section 17 of the Competition Act are applicable. This shows as to how you can refer to one statute section in another statute. So this is more of a practical utility section and nothing much to talk about in this particular section. It is basically saying that how are you making a reference to one section, subsection, clauses. So in a law, you have section, subsection, proviso, all these things which we are going to learn more in the interpretation class. Let us now move ahead and talk about section 29. So section 29 talks about saving of previous enactments, rules and bylaws. So it basically says that if the law is, the provision of act respecting the construction of act, regulation, rules or bylaws after commencement of this act shall not affect the construction of any act. So it is saying basically that if when this law came up, General Causes Act, prior to that, if there is something which existed, that will continue. So this is what is the purpose of this. So it basically says that the new act's rules of interpretation will not change how old laws are understood. Let us try to understand by way of an example. So under 1995 rules, it said this is an hypothetical example. Graduate degree meant any university degree recognized at that time. Now under 2025 Act, graduate degree is defined more strictly to exclude certain distance education degrees. Now, still for matters governed by 1995 rules, the old meaning will apply and not the new restrictive definition. So this is what you have to see, that the previous enactments, rules and bylaws under the General Clauses Act were same. I don't think Section 29 now applies to any of the provisions, because this was something which was there for the purpose of the laws which were in existence prior to the General Clauses Act 1874. Okay, now 30. So it says basically application of Act to ordinance. So you may be knowing what is an ordinance. Any one of you? What is an ordinance? What is an ordinance? Any one of you? Ordinance. Have you heard about the word ordinance before? Okay. Ordinance, any one of you? An order made by authority, Daksh. Okay. Any sudden law. Okay. So see, now we don't have parliament in session. So whenever there is parliament not in session, who can make law? Law can be made by the parliament only at the permission of the president. But there are situations where legislature is not into operation. Like at present, the bill is, the legislature is not working. And there is an immediate need for a law to be passed. So in this situation, the government recommends that particular law to the president, and president pass an ordinance in absence of the legislature. Now this ordinance is valid for 6 months. Within 6 months, it needs to be presented to the parliament for its approval. And that is how it is an example of the ordinance. So ordinance is an emergency power, and it can be given to the executive only to meet the emergent situations. Like one example could be, an example of immediacy can be seen by the ordinance passed in 2011 to give IIT Kanchipuram the status of Institute of National Importance, so that students could be awarded their degrees on completion of their courses. You can see the farm laws were passed as an ordinance. Later on, they were again repealed. So ordinance, in absence of the legislature, president can pass a law that will be referred to as ordinance. Am I clear? So this section basically talks about that, and it is saying that all the provisions relating to section 9, 13, 25, 40, 43, 52, and 54 of the section and 25 shall be deemed to include ordinance in the act. So this is, I think, this is a general provision and not very much related to you people. So it is fine. You have understood ordinance, what is ordinance. So that's it. This is how we complete the General Clauses Act. We have covered all the sections, all the provisions of the General Clauses Act. I gave you sufficient examples as well. And I look forward to any questions you have or any clarifications you have. I will be happy to answer. Any questions or any clarifications you have? Yes, there are multiple cases, Sushmita, where the ordinance was there, but they cannot become law later. However, there are very rare cases, right? Like if you generally what happens is government which is in majority or power, they only come up with ordinance. So they have that particular numbers, because for passing a law, you require assent of both the houses, na? Lok Sabha as well as Rajya Sabha. So many a times you may come up with an ordinance as an emergency rule, and then you get it passed. So under the constitution, there are mechanisms. So there is a, larger bench court sitting and deciding this issue, that whether uh, yes, I agree to you, Karishma, that the language of this chapter is a bit way technical. because it is core legislation. So it is a bit technical, but I have tried to explain this in simpler languages. Try to understand them by way of examples. You don't have to write a legal language in your answers, but you have to simplify in a simplified way. You have to explain. And most of the questions which are coming in your examination is with reference to immovable property, section 9, 10, 11, 12, 13, 24, 26, 14, 16. So these questions I have already shared in the PPT. It will be easier for you to locate, and then you will be in a situation to handle them. Right? So you don't get intimidated by the legal language. You have to understand it. Once you have understood, then it becomes easier. Yes, if a action has been taken in the ordinance, it will be considered as valid. Sushmita, if a action under the ordinance has been taken, that will be considered as valid. That is why the law has come up, right? Otherwise, what is the purpose of having the ordinance if there is no validity to the action which is taken there? Yeah. Okay. Any more questions? Let me see. Okay. So if you have any further questions, you can ask me. I'll be happy to answer them. I think in examinations, they don't ask for section, they ask for concepts. So because I have seen all your questions, nowhere it is mentioning about section. It is talking about the concept, or it is giving you an example and then explain. Like, for example, it will say, explain the concept of immovable property, oath, like that. So then you have to explain that. And while explaining, you should mention the section. But they will not directly ask you that this section means what. I don't think that the questions are framed like that. Till now, I have not seen a question like that. Yeah. My simple advice to you people for preparation would be that prepare your own notes. It is always better to prepare your own notes. When you prepare your notes, you remember the sections also, as well as the examples. So it becomes easier for you to recollect during the examination, do the revision. So please do follow that process. Okay. So I will be sharing the PPT as well as a question bank with you people. So kindly practice on General Clauses Act. Still, you have any questions, you can come back with the questions in tomorrow's class. Tomorrow, we will begin with interpretation of statutes. So if you don't have any further questions, we will call it a day. Have a nice evening, the remaining one. All the best. IT team, now we can close the session. Yes. I don't think there are any other questions. If there are no questions, you can close it. Yeah. Thank you. Thank you. Good night, everyone.